Hi there. In this video, I'm going to be looking at the influences on human resource management, but focusing on the legal influences and the current legal framework. Okay, so firstly, let's look at employment contracts. Okay, now, a contract does not need to be written. However, it is advisable to write it down, but it doesn't need to be written. But it is valid and legally enforceable when a few conditions are met. Okay, so the parties involved intend to create a legal relationship. The offer does not contravene any public interest. Both parties have the capacity to contract. For example, they are old enough to make the contract. Both parties obtain a benefit. One party offers and the other accepts the offer. And finally, consent is genuine and not pressured or forced in any way. Okay, so let's look at how these employment contracts came to be. So we've got common law here. Okay, now under common law, both parties, employers and employees, have basic obligations in any relationship. Okay, regardless if it's formal or informal. Okay, so for example, let's have a look at employer obligations. They're obligated to provide work. They're obligated to pay income and expenses, and they're obligated to meet requirements of IR or industrial relations legislation. And they're also obligated to maintain a duty of care as well. So on the other hand, we've got the employer obligations. So what employees are obligated to obey lawful, reasonable commands made by the employer, use care and skill in the performance of their work activities, and act in good faith and interests of the employer. Okay? Now, in the current legal framework as well, we've got some minimum employment standards. Okay, now, 10 national employment standards have been developed in consultation with business, unions, and the community. They must be provided by employers and state minimum conditions for employees. They've been planned to provide a greater safety net for employees, particularly for the most vulnerable and low-paid employees in the workforce. Now, these 10 are maximum weekly hours of work, requests for flexible working arrangements, parental leave and related entitlements, annual leave, personal carers leave and compassionate leave, community service leave, long service leave, public holidays, notice of termination and redundancy pay, and the provision of Fair Work information statements. Now, on minimum wage rates, from 2010, the employee's base rate of pay for ordinary hours worked has been determined by a few factors. The award or agreement that covers the employee, which is the rate of the rate of pay cannot be less than the minimum wage, and the national minimum wage. So this applies to employees not covered by awards or agreements, and it's reviewed annually by a panel of 7 members of Fair Work Australia. So now let's look at some of these contracts. We've got awards. Okay, now awards are legally binding documents containing minimum terms and conditions of employment, in addition to any legislated minimum terms for an industry or occupation. Okay, they may include minimum wages, penalty rates, types of employment, flexible working arrangements, hours of work, rest breaks, allowances, etc. Awards are adjusted for increases awarded in annual national wage cases, which are heard by Fair Work Australia, and they cover a large proportion of employees in lower skilled occupational groups in hospitality, retail, and community service sectors. Okay, and awards cover everyone around the country in the exact same, with the exact same conditions in the same industry. Then we've got enterprise agreements. Okay, now enterprise agreements are collective agreements made at a workplace or an enterprise level. That's why they're called enterprise agreements. Between an employer and a group of employees, or an employer and a group of employees in a union, for example, about terms and conditions of employment. They offer broader terms and conditions than a modern award, and are an alternative to a modern award. Okay, now they can be equal to or go above and beyond a modern award, but they can't offer less than what's in an award. Okay. So we've got a couple of enterprise agreements we can look at. We've got single enterprise agreements. Okay, now made between a single employer and a group of employees. They can involve more than one employer in a limited case. For example, where two or more employers are engaged in a joint venture, for example. Okay, we've got multi-enterprise agreements made between two or more employers and groups of their employees. This may occur if they share common funding, operate collaboratively, and have a common regulatory system, for example, such as a group of hospitals. And we've got greenfield agreements. These are single enterprise or multi-enterprise agreements relating to a genuinely new enterprise of the employer or employers that are made before any employees to be covered by the agreement are actually employed. Okay, these are made with one or more relevant unions. So this is before they've even started hiring anyone, as opposed to the other two agreements, which have already current employees. Now, enterprise agreements must pass a better off overall or a boot test compared to the modern award. So, as I said before, enterprise agreements can be equal to or greater than an award, but they can't be. You can't have someone worse off from a modern award by being on an enterprise agreement. Some other employment contracts. We've got individual common law employment contracts, or just common law contracts. These exist when an employer and an individual employee negotiate a contract covering pay and conditions. These are more common in the private sector, particularly in non-union enterprises or managerial professional levels. We've got independent contractors, often known as consultants or freelancers. They undertake work for others. However, they don't have the same legal status as an employee. Okay, they generally undertake a contract, service, or project for another business, work for multiple clients at a time sometimes, and they have set terms for a specific project for their contract. They control their work, they delegate some of their work to others, so they subcontract, and then they generally submit an invoice at the end of their task and get paid. We've also got contracts for casual work. Casual employees have contracts with employers for short-term, irregular, or seasonal work. Their work period may vary, and they're paid on an hourly or daily basis, and not entitled to paid leave. Now, most casuals are female or young people, often students, and a lot of employees prefer them as it reduces costs for recruitment, dismissals, and any other ongoing costs as well. We've also got part-time contracts. Now, part-time employees have a continuing employment contract and work less than 35 hours per week. Unlike casual employees, they do have access to employment entitlements offered to full-time employees, but on a pro-rata basis, so they only get a proportion of what full-timers get based on how much they work. Other things to consider in the current legal framework are OHS or WHS, Occupational or Workplace Health and Safety, and workers' compensation. Employers must provide a safe system of work, ensure employees are trained and supervised in their work. All employers must take out workers' compensation insurance. Employees are also responsible for taking reasonable care for the health and safety of others as well. And workers' compensation provides a range of benefits to an employee suffering from an injury or disease related to their work. It is also provided to families of injured employees when the injury, disease was caused by or related to their work. Another piece of legislation to be aware of is anti-discrimination, and equal employment opportunity. Discrimination occurs when a policy or a practice disadvantages a person or a group of people because of a personal characteristic that's really irrelevant to the performance of the work. It includes harassment, offending behavior or intimidation, and vilification, which is a public act that's discriminatory and incites hatred. Anti-discrimination legislation has been enacted to protect employees from direct and indirect discrimination involved in recruitment, selection, training, promotion, remuneration, that's payments, termination, and opportunities to access any other employment benefits or practices. Equal employment opportunity, EEO, refers to equitable policies and practices in recruitment, selection, training, and promotion. EEO ensures that the best person for the job is chosen. The business gains the person with skills and abilities most appropriate to its needs, and a more positive work environment is promoted. Now, under discrimination laws, it is illegal to take adverse action in employment on the grounds of a person's race, sex, sexual preference, color, age, physical, mental disability, religious faith, political opinion, social origin, national extraction, marital status, career, carer responsibilities, pregnancy, or potential pregnancy. So I hope this brief video on the legal influences, particularly looking at the current legal framework, has been informative. The next video will look at the economic, technological, and social influences on HR management. Thank you.